This morning's docket. Case number 106600, State of Kansas v. Brandon Castleberry.
May it please the court, I'm Heather Sussman with the Appellate Defender Office here on behalf of Mr. Castleberry, and I would like to request 4 minutes for rebuttal time, please.
4 minutes is granted.
Thank you. I can certainly go into some facts if the court would like, given that we have a little bit of an audience. Otherwise, I can go ahead and jump right into my issues if you'd prefer.
Could you spend about 45 seconds on the facts?
Sure. Mr. Castleberry was involved in a drug transaction. There's an allegation that the police informant called Mr. Castleberry and set up a drug buy. He then showed up at a park in Emporia where there was a drug transaction and then led the police on a chase through Emporia and some of the county outside of, or in Lyon County, and then basically got into a tussle with the police officer. So there's a variety of charges, including distribution of methamphetamine, use of a communications device for the phone call, setting up the drug buy, obstruction, fleeing and eluding. That's the general facts of the case.
Thank you.
The first issue I wanted to talk about is the first issue in our brief, which is the sufficiency issue on the use of the telecommunications facility. The Court of Appeals essentially found that the statute requires a communication, and per that communication, because Mr. Foltz, who was the informant in this case, contacted my client, that even though there was no evidence that my client, when he received the phone call, was in Lyon County, that Mr. Foltz's location, which was in Lyon County, actually at the Emporia Police Department at the time he made the call, was sufficient to uphold the conviction on that charge. Our allegation is that it is not. And basically...
Well, let's go back and clarify. You say sufficiency issue. What we're talking about is whether venue was proper in Lyon County. And does it make a difference whether we label venue or that it occurred in Lyon County as an element or as a jurisdictional requirement of venue? There is some quibbling back and forth which it is, but does it really matter?
I think for the purposes of the argument this morning, I think the case law has been pretty clear that even though it's not technically an element under the statute, that it is something that is required to be proven for the purposes of the argument today. So,
and the real issue is no one questions that the informant called on the cell phone and defendant answered. The
correct.
Question is, was there evidence that the receipt was in Lyon County, that he was in Lyon County when he received it? And if not, does the fact that it was generated from Lyon County enough for the statute? That's what we're really talking about.
That's correct. And the Court of Appeals essentially relied on the idea that there had to be a communication in order for this charge to be upheld, and so either end of the communication was sufficient to satisfy that venue requirement. And so even though there was no evidence as to where my client was on the one end of the communication, that the location of the informant in the Emporia Police Department was sufficient to satisfy that. Our argument is that the focus of the statute on the use of the communications device is really focused on the use of the device. And although the Court of Appeals attempted to draw conclusions that a communication is necessarily required because what we're talking about here is a communication device, our argument is that based on the wording of the statute, that the communication portion of the language in the statute is actually there to define what devices may qualify for the purposes of the actual facility. In this case, it was a cell phone, which clearly can be used to communicate. But our argument is that the actual statute does not necessarily require communication or even successful communication, that really the focus of the statute is on the use of the device itself. And our argument then is that Mr. Foltz's use of his cell phone is not the same thing as my client using a cell phone to make that call. And so our contention is that unlike situations where the communication between the two of them may satisfy that element, that the use of the informant's use of the device is not sufficient here. And I wanted to be clear that this is not a case where they charge some kind of aiding and abetting, where you could kind of back into the idea that my client is somehow responsible for the informant's behavior here. They did not charge or instruct on that. And so our argument is that Mr. Foltz's actual use of that device under the statute doesn't qualify to satisfy that venue argument.
Counsel, what was the time frame from the time that phone call concluded until Mr. Castleberry arrived at the park?
There were multiple phone calls, and two of them at least. And I believe from the most recent one between the last phone call that was made before he actually got to the park, so the least amount of time between the two was around 45 to 50 minutes or so. And our allegation is that, certainly from Emporia, he could have been anywhere when he received that phone call.
Didn't you have an officer testify that you could get outside the county in 45 minutes from Emporia?
I believe so, yeah. Yes. And there was some allegation by the state. The state tried to argue that there was that there was sufficient evidence because my client had testified that he lived in the county, that he lived at a particular address, was staying in a motel. That's all well and good to show that he generally was around in Lyon County, but certainly at the time that the phone call was made, the fact that he otherwise lived in Emporia didn't necessarily mean that that's where he was. I'm in Topeka every day, and yet I don't live here. So, I think that while that information might be helpful for other reasons, it doesn't answer the question.
What venue is proper if you have a use of a communication device that's out of the county? Can you not then charge it? Is it a case that can't be charged if you have a recipient in one county and the call generated from another?
Well, our argument would be that the venue would be proper where the actual use of the device took place. And the problem here is that it may have taken place in Lyon County, we just don't know because they didn't actually put on evidence of that. So if Mr. Castleberry had been in Lyon County, then there would have been venue in Lyon County to charge that. The problem is they didn't actually put that information on. If he was in another county, then our argument would be that the venue would be proper in the county where he actually was.
Let me just make sure.
Go ahead.
Excuse me.
Yeah, go ahead.
I'm sorry, I didn't mean.
No, I'm fine.
Yeah. Let me just make sure I understand the state of the record. So there was testimony from an officer that one could be outside the county within 45 minutes, or?
I believe so, yes.
Okay, so you had that testimony, and then you had testimony about where the informant was standing when the call was made. Mm-hmm. But you had testimony about your client living or staying somewhere in Lyon County. Mm-hmm. I'm puzzling over direct versus circumstantial evidence. You're saying there was no evidence.
There was no evidence, no.
Well, no direct evidence.
No direct evidence, and to the extent that there was circumstantial evidence that that he could have made it to that he would have
received the call within the county limit.
Right. He could have been a block away and received the phone call and still have,
That's
wandered around and have taken 45 minutes to get there. So
that's my point. So there was indirect or circumstantial evidence of him being in the county when he received the call.
Well, and our response to that is that because it's not clear one way or another whether he was actually in the county, and there's nothing else to support the idea that he was there. I think there was also an allegation that he had talked on the phone to the informant's girlfriend, but that again doesn't place him in Lyon County at the time. And
I understand.
Our argument is that even under the potentially circumstantial evidence, it doesn't weigh enough one way or another in favor of this to satisfy the sufficiency element.
Okay.
Can I return you to the statute, the language of the statute, when you are focusing on the use of the communication facility and the fact that it defines a communication facility as a cell phone, right?
Mm-hmm. That's one of the options.
So if someone hides drugs inside a cell phone and passes it to someone else, have they used the communication facility to distribute drugs? Because and where I'm headed with this is if you have to use the communication facility for the purpose for which it's designed, then your argument sort of evaporates, doesn't it?
Well, and I certainly would not encourage any prosecutors to use the statute for that purpose necessarily, but I wouldn't be surprised if that had happened somewhere.
But under your interpretation, that would be included.
Under my interpretation, that would be included, yes. And I mean, and I guess that's to the extent that the court might have an issue with that, I would argue that fault lies in the legislature's lap for not making it perhaps more explicit. And like I said, this is partially based on the fact that the actual definition of what constitutes the communication facility is sort of separated out from the upper part of the statute that talks about what the actual crime is. And so if they want this to include an actual communication, they could have included it there.
But before you run out of time, I want to move you to the fleeing and eluding, and
Yes.
you were relying on Richardson.
Yes.
But we have a factual distinction here, or a pleading distinction. Here it's pled reckless as well as the 5 moving violations. But I don't believe in Richardson they had that reckless. You understand what I'm asking you?
Right. I mean, we've kind of got a complicated problem here in that it's both potentially an alternative means issue, but then also the multiple acts problem and the lack of definitions of what acts would constitute the moving violations.
If it were not an alternative means, then it would be harmless because the reckless is there. The moving violation, the failure to define moving violation would be harmless if the jury could have relied on reckless driving.
Well, and that's, I mean, they certainly don't have to be unanimous on what the actual alternative means is. Our argument is still that even if there's half of the jury that relies on the moving violations without a proper definition of the moving violations, you still have a problem. And one of the things that I wanted to take my time, and I obviously am out of it now, to end with clarifying here is that the Court of Appeals in this particular issue, and this is the second issue, relied on the fact that this was a harmless error problem because there wasn't evidence, because basically all the evidence of the traffic violations that we were talking about were over 100 miles per hour, which would have not qualified as anything other than moving violations. And what I wanted to make the point of today is that that's not necessarily an accurate reflection of the record. In fact, on volume 9, pages 245 and 251, there's several pieces of testimony there where the actual speed was significantly less than 100 miles per hour, and so depending on the specific instances, it might not have qualified as a moving violation under that particular statute. And so to the extent that the Court of Appeals said it was error, but then said it was harmless, and our argument would be that it's not harmless.
Before I sit down, I'd like to go back to that first issue that we spent a lot of time on.
Yes.
I'm not sure how you came down on whether it was an element or venue or jurisdictional. Could you clarify that for me? Because I'll then follow that up with another question.
I believe the state of the law is that it's not technically an element of the statute, but that for the purposes of the venue, it is still an evidentiary fact that has to be proven. And so our argument is that the way the wording of the statute is in this particular situation, we can't rely on that communication being on both ends because it doesn't require communication under the statute either.
And what would be this court's standard for reviewing whether there was, in fact, that element made proven?
Well, I mean, for the purposes of the venue issue, then your standard of review is unlimited because the venue is jurisdictionally, you can consider that de novo. Under the sufficiency, it would be in the light most favorable to the state.
All right,
Does that
thank
answer
you.
your question?
Any more questions?
To carry that further, in the light most favorable to the state, a rational jury could have found that fact to exist beyond a reasonable doubt. Don't they have to find venue beyond a reasonable doubt as well?
They have to find, I would argue that they have to find venue beyond a reasonable doubt. And I don't think that even with the circumstantial or potentially circumstantial evidence there that they could do so beyond a reasonable doubt based on what they had. This is one of those situations where I think the state could have put on evidence to satisfy this element and they just didn't here. So it's not that this is somehow impossible to prove.
They perhaps could have put on the cell phone records to indicate when.
Yeah, I mean, we don't even know for sure that my client was actually even on a cell phone. He might have even been on a landline when he answered the phone. At that point, you could associate it with an address even. So, I mean, I think this is certainly a situation where they could have put on evidence and just didn't think they needed to. With that, we would respectfully ask that based on these two issues and the issues contained in our brief, that the court vacate and remand for further proceedings in accordance with the brief. Thank you.
Any more questions? Thank you, counsel.
Thanks.
May it please the court. I'm Jonathan Noble. I'm Assistant Lyon County Attorney, and I'm here to argue on behalf of the state today. I was intending originally to begin with issue 4, then move to issue 1, and then address the other issues as time allowed. However, since there was a main focus on issue 1, if the court would prefer, I'd be happy to go ahead and address the state's position on that issue now.
I don't think we have a preference, whatever you're most comfortable with, counsel.
All right. Your Honor, on issue 4, is the state's position that this is not an alternative means case, and thus a unanimity instruction. I always get tripped on that word. It was not necessary. I'd ask the court to refer specifically. This is most like State v. Ahrens and State v. Aguirre. Aguirre, which was found by the Court of Appeals to be on point. Both of those cases include the analysis set forth here in State v. Brown that was decided in 2012, indicating that options within means, that as long as they're not stating a new distinct element, specifically a new mens rea, a new actus rea, and in some cases a new causation, should be found to be options within means. In State v. Ahrens, it was a DUI case where the court had in front of it operating or attempting to operate. In State v. Aguirre, it was aggravated intimidation, persuading or dissuading the victim, or attempting to persuade or dissuade a victim from testifying. In this case, the specific instruction that was issued was concerning distribution. And for distribution, the two primary elements of that crime are distribution and a controlled substance, and then an amount, since I guess that would be a third one. But in this case, the question is what is distribution? And the instruction in the statute provides that it's actual, constructive, or attempting to distribute methamphetamine. Well, in this case it was methamphetamine, but more generally a controlled substance. The state is asking to find, like in Ahrens and Aguirre, that this is an option within means case, and thus the super sufficiency requirement is not necessary. If the court doesn't have any specific questions, I would go on to issue number 1. Your Honor, the statute that defines the crime of illegal use of a communication facility makes it illegal to use a communication facility in the connection of a drug offense. In this case, the distribution of methamphetamine.
Doesn't it also define communication facility as a phone?
It specifically defines communication facility as any and all public, private instrumentalities used or useful in the transmission of writing, signs, signals, pictures, or sounds of all kinds. Includes telephone, wire, radio, computer networks, beepers, pagers, and all other means of communication.
So I'll ask you directly, does a communication facility, in terms of our interpretation of this criminal statute, include a cell phone or a landline phone?
It does, Your Honor. And not only does it include the phone, but if I were to use my cell phone.
And the defendant is the one that has to use that communication facility.
That is
the
correct.
fact that a co-defendant or a co-conspirator or a partner in crime has used that doesn't meet the requirement of the defendant's use.
Your Honor, only if the court specifically finds that the endpoint of the communication facility is all that's required. The state's position is that when a cell phone is used, it sends a cell signal out to a tower that bounces out to another tower that eventually will rely at another
That's all.
endpoint.
That's all well and good, and I think we all understand the limited knowledge of technology that we need to understand that it takes two to have a telephone conversation. But what I need for you to tell me is, under the statutory language, why we have to find, or how we can find that the caller's use in Lyons County is equal to the receiver's use in Lyon County. And don't we have to find that under your theory?
Yes, you have to find that not only is the endpoint of the communication, but also the instrumentality of the communication is pretty much a chain from one telephone to the other telephone.
And so I'm trying to clarify that, because you're not relying on the existence of circumstances that would be sufficient for a jury to reasonably infer that Mr. Castleberry was in Lyon County when he received the call.
It is still the state's position that there was circumstantial evidence that he was within the county.
And what would that be? I'd like to make a list of the circumstantial facts that would support a reasonable inference that he was in the county when he received the call.
Yes, Your Honor. Specifically, there was testimony by the defendant that he had moved into town and that they were staying at a motel. And while there was testimony that from an officer that you could get outside of Lyon County in 45 minutes, which is true from personal experience, that would be the circumstantial evidence that, as far as I understand it, that was presented. That being said, it's not a lot, but it is the state's position in a light most favorable to the state, that would rise as sufficient evidence, along with the argument that if the court finds that a communication facility is more expansive than just the endpoint of the communication, then there's certainly enough evidence that a jury could find that Mr. Castleberry was using a communication facility within the jurisdictional requirement.
Because of the tower that he would have had to have employed to have the conversation? Is that what you're saying?
That as well.
Does a tower qualify as a communication facility?
Well, the statute indicates all public and private instrumentalities used or useful in the transmission of. Therefore, if there's a tower in the county, then if that tower transmitted a signal, then he would be using that tower as well as his own phone.
If he was talking.
If the guy had called and not gotten a hold of him, he wouldn't have done anything. But if he connected and had a conversation, he too was using the tower to communicate.
What about the other evidence that I visited with your opposing counsel about? Was there evidence about where he lived or hung out, or?
There was. That was
Okay.
That was specifically that he had moved into town and that there was a motel. I don't quite recall the exact specific
The point is, it was in Lyon County.
But that was in Lyon County.
So that's additional circumstantial evidence that he may have been in the county at the time the call was made.
Yes, Your Honor.
Okay, thank you.
Was there any evidence presented about what towers were in Lyon County and which would have been used by the informant when he made the call to the defendant?
No specific evidence about those
So
towers.
this whole business of towers really just doesn't matter in this case because you didn't connect those dots. I mean, I understand your argument. I'm just saying, where's the evidence that there's a nearby tower that had to get used?
That's correct, Your Honor.
Is your opposing counsel correct that we don't even know it was a cell phone?
I am. That is correct. I don't know that I don't believe that there was anything in the record that indicated exactly what he was calling on. If it was not a cell phone, then it would be using a landline, which there would definitely be landline.
So you're
What he was-
go ahead.
What he was receiving the call on,
Yeah.
not making the call, correct? Who initiated the call?
Who initiated a call? Originally it was Foltz, but then there was some communication back and forth. And Foltz being the co-defendant, that was the original. But it was never clear from my interpretation of the record exactly what Mr. Castleberry was using as his communication endpoint.
To be fair, we do know that defendant had a cell phone during the transfer, because didn't he say, here, talk to your girlfriend, or was that Foltz that gave the phone?
No, that was Mr. Castleberry.
Yeah, so he had a cell phone at the place of
At the
transfer.
place. We just don't know if that was necessarily what he was using
Right.
at the other play, or
But-
during the other communications.
But under your theory then, a government agent could sit in Topeka and call drug dealers in all 104 other counties and then simply go round them up and prosecute them in Shawnee County.
Under the state's theory and the way that the Court of Appeals did interpret that statute, that would be correct.
Do you have any support or case law that supports your notion that any apparatus used in the communication satisfies communication facility? In other words, I think what you were about to say, if you used a landline, the telephone pole and the telephone wire that would connect would be part of the facility. Is that what you were about to say? I think you were.
Yes.
And what
however,
support do you have for that notion?
I actually
that goes along with the cell phone tower.
I believe that this would be an issue of first impression. Beyond a plain reading of the statute, I don't believe that there is specific authority that would support that position. If there are no more questions on issue 1, I would move on to issue specifically 2, the moving violation instruction and the failure to give that instruction. The Court of Appeals entered into found that it was error, failure to give a specific instruction on what a moving violation is. Then they engaged in a harmless error analysis. The state's position that it was in fact harmless error, and while there was not testimony that he was moving at 100 miles per hour the entire trip, which if you're going through a residential area, it would be impossible to maintain speeds at 100 miles per hour. There was testimony that that the speed reached as high as 120 miles per hour, and that Castleberry drove through at least 8 intersections controlled by a stop sign or a stoplight, and that he emitted his speedometer indicated that he was driving over 100 miles per hour.
So you want us to make the factual determination that it would be find as a matter of law, all of the facts in the record establish moving violations. That's what you're asking us to do?
Yes, Your Honor. I do note that there is, in Richardson, there was specific language that indicates that the court would not step into the shoes of the jurors and convict Mr. Richardson of 5 moving violations of the choice, and because the jury didn't make the necessary determination of guilt beyond a reasonable doubt on all the elements of the charges. However, when the harmful error analysis indicates that whenever the omitted element was uncontested and supported by such overwhelming evidence, that the jury verdict would have been the same without the omission.
You haven't cross-petitioned or challenged the Court of Appeals determination that this was error, have you?
The state has not challenged that was in fact error, no. If there are no further questions, I would stand on my brief for the remaining issues.
I'd like to go back to the question that was posed to opposing counsel on the first issue about venue, jurisdiction, however we're characterizing it. What is your opinion on what our standard of review would be on that issue?
Venue is a necessary jurisdictional element, and therefore there is a de novo review on jurisdiction. Specifically, KSA 222603 indicates that any way when a crime is indicated to have, when there's some confusion about which specific county it has occurred into, the crime can be prosecuted under venue, under any county where it occurred. If we're using venue as another word for jurisdiction, then that in statute, by logical extension, although I don't have specific support in regards to this conclusion, then jurisdiction should be, by reading, if we're using jurisdiction and venue interchangeably, then jurisdiction should be in either one of those counties where it occurred.
Okay, what I'm getting at specifically is, I believe it was Justice Johnson who asked you to tell us all the facts that the state had upon which it relied to establish venue, and you gave us several facts.
Yeah.
My question is, how are we to review what you told us?
When it comes to the pure interpretation of the statute in a venue is de novo review. However, since it's raised as a sufficiency argument, it would be in the light most favorable to the state whether a reasonable fact finder could find beyond reasonable doubt that Castleberry was guilty of using a communication facility in the facilitation of distribution of methamphetamine.
All right, thank you. Any more questions?
This may be a little off topic, but he got 65 months a controlling sentence. If we disagree on the use of a communication facility, what piece of that 65 months was that?
Your Honor, I'm not 100%
Were they-
certain. I believe
Were they all consecutive, or were there some concurrent?
Your Honor,
If you don't know off the top of your
I
head, it
don't
doesn't
know off the
matter.
top of
It's
my
in the
head.
record. It's in the record. We'll look. Okay, thanks.
thank you.
Thank you. You reserve 4 minutes for rebuttal.
Yeah, just to answer the court's question about the controlling sentence here. Let me look real quick. Sorry, going through my. Yeah, the use of the communication facility was run concurrently, so I believe he probably would still be serving the because the actual controlling charge was the distribution.
And
So-
if that's the only issue you win on, then do we still have to remand for resentencing if it was run concurrently?
Specifically for resentencing, I think that, well, it wasn't the primary charge, so
It wouldn't change the calculation, or?
it wouldn't probably change the calculation. It was run concurrently. I mean, I suppose for correction of the journal entry, perhaps, although that could probably be done at that point, if that's the only issue. If there were no further questions, I will waive the rest of my rebuttal.
I've got one. In the first recorded conversation between the informant and the defendant, the conversation indicates that the defendant asks the informant, "Where are you?" and he says, "I'm in town." Doesn't that establish that the communication facility is being used and that they're in Emporia?
That the informant asked that Mr. Castleberry asked the informant if he was in town. Well, I mean, I think that that's still dependent on the idea that you're relying on the informant's position to satisfy that element.
It seems to me that the statute's designed to get at the use of this equipment in order to facilitate a crime. And so everybody's got to have a phone, everybody's got to be on it, and it even seems the defendant knows that the person he's arranging the drug buy with is in Emporia.
Well, and my response to that, Your Honor, is that if the legislature intended for the someone else's use of a communication device to satisfy the jurisdictional element here for the purposes of being able to charge him in Lyon County, they did so inartfully, I think, is the problem. And so our argument is that if the focus of the statute is on the use of that device, it's the device that the defendant's using. I mean, he can't just yell out into the midair and talk to somebody on the phone otherwise. I mean, he has to use a device in order to conduct that conversation, and our argument is that that's where that particular statute stops, is with his behavior. And so to the extent that the legislature otherwise may have intended, they did not expressly provide for that in the statute in a way that would have made that clear. And if the statute's not clear on that, we would argue that under the rule of lenity, it should be interpreted in the interest of our client.
Any more questions? Thank you,
you.
counsel. Thank all of you, both of you, for your arguments this morning. The court will take this matter under advisement.